against Palestinian civilians, particularly in the West Bank and access restricted areas of Gaza, continue to be a serious concern. Since 2013, Israeli security forces have increasingly used live ammunition in the West Bank and the access restricted areas in Gaza, and this has led to an increase in fatalities and injuries. After a large-scale Israeli military operation on Gaza began in July 2014, many deaths occurred as a result of the military operation and in the context of demonstrations against the Israeli military operation. According to information before us, many of the victims did not appear to pose a lethal threat to ISF forces or any other individual. And we have also received allegations of executions of Palestinian detainees during the military operation. I would appreciate it if the distinguished delegation would respond to these allegations. I would like to give one concrete example of seemingly excessive use of force. 2 teenagers were shot and killed at Betunia in May 2014 in demonstrations commemorating what Palestinians call Nakba Day. According to information before us, the Israeli security forces faced no threat when the 2 boys were killed. At sea, the means used by the military navy to enforce the imposed restrictions put fishermen physically at risk, and there are also concerns regarding the demolition of properties during arrest operations, which seem disproportionate. And the problem of excessive use of force is compounded by the absence of accountability. Could the distinguished delegation indicate whether the State Party has launched credible and independent investigations into all allegations of excessive use of force? What measures has the State Party taken to ensure that the perpetrators are promptly prosecuted and punished? Could the distinguished delegation provide information on the number of investigations conducted and convictions resulting from such investigation? In 2011, a new policy was announced by the Military Advocate General, according to which criminal investigations are automatically opened into incidents involving fatalities. What improvements in accountability have been achieved by this new policy? We also have concerns about the so-called operational debriefing, which is an initial inquiry overseen by the Israeli Defense Force unit commander involved in the incident. How can this be reconciled with the principle of independence of investigation? Victims of excessive use of force should have an effective remedy. What measures has the State Party taken to ensure access to justice for Palestinians affected by excessive use of force? Lastly, Mr. Chairperson, in the list of issues, the committee asked the State Party to provide updated information on investigations related to Operation Cast Lead and other recent incidents, such as the case where a family had been confined to a house and the house was subsequently shelled by the Israeli Defense Forces. Could the distinguished delegation answer this question, which we asked in the list of issues? Thank you very much, Mr. Chairperson.
Thank you, Mr. Iwasawa. The next speaker on my list is Mr. Kalin. Mr. Kalin, you have the floor.
Thank you, Chair. I also would like to thank the distinguished delegations for the answers provided, in particular answers to issue number 3 with interesting examples there. It was also interesting to hear about the funding problems for the Minerva project, even though in the long run, I might suggest it would rather be on the state parties' shoulders to finance such kind of exchange. Allow me, even though I did not raise the issue, just to ask one question, and certainly Mr. Flinterman will follow up to that, on the answer regarding the non-applicability of the covenant. There was a mention of that according to state practice, human rights law does not apply when international humanitarian law applies. I wonder to what kind of state practice you're referring to, because this is a proposition we have not heard from other states. Most states that are discussing with us do agree that to some extent the covenant has extraterritorial application. There is one well-known example of an exception from that position, but that the two bodies of law would not apply, but at the same time, that's rather unique as a proposition. Of course, it's not full application, and the International Court of Justice has said everything that is needed about the relationship between the two bodies of law. As regards issue number 10, thank you for the answers provided. May I very kindly ask to, in the second round, also provide answers to the questions that were not answered. I did not get an answer on whether there are procedures at the border for those who ask for asylum at the border. Do I have to take your silence to indicate that there is no such procedure? Do I have to take your silence to indicate that authorities in charge of securing borders are instructed to hand it over asylum seekers to the authorities of the neighboring state? I really would like to have an answer to that. I did not get an answer to the question regarding measures taken in cases of allegations of the use of violence against asylum seekers by Israeli authorities. Our question did not suppose that there are cases of such violence. We were talking about how are allegations handled in these cases. I only got the answer regarding the future detention regime, limited to we are still studying it, but the deadline is running out. 1st of January next year, when it no longer can be applied, is not far away. So if you could give me some, at least assurances, what the direction will be, and that that the new provisions will comply with the courts. And I'm saying that because, as you know, there have been some political voices suggesting that maybe it would not be such a good idea to implement that decision. But that's not what we have to discuss here, these political discussions. Still, I would be interested what your thoughts are. I got a partial response on the respect for non-refoulement, and I was happy about that response, the assurance that the principle of non-refoulement is fully respected for rejected asylum seekers. However, I would like to know how this is achieved, how it's technically done. Is it just de facto tolerance, but immigration authorities could order the deportation any time? Or do you have, as many European countries have it, a kind of subsidiary protection that is granted to these people? If the latter would be the case, I would be more assured that there is, in fact, in law and practice, a protection against refoulement. I think it's important to have a real dialogue, that we are going a little bit beyond what we prepared and have a real exchange here. I'm now moving on to issues 15 and 16 on torture and ill treatment. And I'll take the two questions together. They are closely related. Of course, this is a very vast topic, and we have received a very large number of cases, submissions on the issue, on individual cases. I would not like to go into individual cases, but rather, because time is limited, focus on the structural issues. Some have suggested that your system is quite a watertight system to protect those who, in fact, if not lawfully, but still have engaged in abuse, ill treatment, as prohibited by Article 7. And I very much would hope that you are able to convince me of the contrary, that it's not watertight. What are the elements of this system? First element, the definition. You don't have a definition of torture, but you're referring to several provisions in the penal code, such as, for instance, assault. The point of departure for me is that quite some time ago, the Supreme Court has authorized the use of what is called moderate physical pressure. And of course, there is a very fine line between moderate physical pressure that always exists, even if someone is apprehended and handcuffed, between that and what would fall within the notion of not only torture, but also cruel, inhuman, and degrading treatment contained in Article 7. By the way, unlike the Convention on Torture, our covenant does not make that distinction between the different categories. They're all equally prohibited in an absolute manner, so we don't need to engage into questions of what is more serious or less serious. So it's a fine line. And I just want to test it. Let's take assault. There are many allegations of the use of what is called the banana position, people being bent backwards. And this seems to be very painful if it's used repeatedly over long periods of time of interrogation. It does not cause wounds. It does not lead to lasting health damage. Can you tell me, with reference to court decisions or commentaries of noted writers, that this is assault as defined in the penal code? What about psychological torture? Sexual humiliation, the threat of sexual humiliation, or the threat to bring a female relative and rape her, again, often alleged. Is it covered? Under what article of the penal code? Of course, I note also sections 277 and 280 regarding prohibited pressures by public servants and abuse of office, and these are certainly very good provisions that might cover some of what I just said. But then, if moderate physical pressure is allowed, and this kind of treatment is allowed, then it would not be unlawful, and then these two provisions would not be applicable. So, what exactly is here moderate physical pressure? What are the methods allowed? What are the methods prohibited? And how is the relationship between Articles 277, 280, where only unlawful conduct by state authorities and agents is punishable, in the context where certain methods that might be problematic are allowed? So that's the first element. Now, the defense of necessity. The report says that you're not revisiting that issue. I fear we have to revisit it. And I don't want to go into all the details. Again, we could talk a long time about it. But the question is, does necessity here refer to the objective side of the crime, meaning that no crime is committed in case of necessity, or does it refer to the subjective side, namely, the crime has to be investigated, there has to be a trial, and then at the end, the punishment might be lowered or even excluded because the degree of guilt on the side of a perpetrator is lower because of necessity. Two very different concepts that have a huge bearing on whether investigations and trials are conducted. If it's from the beginning on no crime, then of course there is no investigation, no trial. But then who decides whether necessity applied or not? Can you tell us in how many cases necessity was invoked to justify refraining from opening formal investigations? To know this number would for me be the test. If you can show that there have been cases where necessity was invoked, but still formal investigations were opened, there were trials, and then in the end it turned out that this was a case of necessity, I still would have some concerns, but they would not be as important. Third element, probably gaps in penal law, the defense of necessity. And the third element, exemption from the obligation of audio or visual documentation of interrogations. An exception from a rule that applies in all other cases, that privileges in this regard cases where security offenses are at stake. Your explanation is this might help extremists. I take that point. There are very legitimate interests that the results of interrogations do not fall into the wrong hands. But written minutes of interrogations also can fall into the wrong hands. And there are many instruments and technical measures, organizational measures to ensure that such documentation that is of an audio or visual nature does not become public or fall into the wrong hands. So I'm, again, not convinced there. Fourth point, the transfer of the Inspector for Complaints against the Israeli Security Agency to the Ministry of Justice. Very much to be welcomed. That's a step in the right direction. However, what counts is the effects, and I simply would like to know, since the new system came in place, and I think that's already quite some time ago, it was instituted last year, in how many cases has the introduction of the new system led to the initiation of criminal investigations and criminal proceedings? Is the number still at 0, as it used to be before? Then a question on the preliminary investigation as such. Certainly, again, a good organizational measure, but does it always apply also in cases of clear evidence? Because in that case, it could act as a filter that does not exist in other cases, where the police in clear-cut cases can go ahead with investigations. Finally, regarding children and juveniles, young people, again, lots of reports. I don't want to go into them. I want to understand the system. Are there any provisions that ensure that robust treatment permissible to be applied to adults cannot be used in the case of children? What measures are taken where children are arrested in a security context to ensure that the best interest of the child, that's explicit in the Convention on the Rights of the Child, but implicit in our Article 25 of the Covenant, how is it ensured? What measures, practical measures, are taken that in such cases the best interest of the child is ensured? Thank you very much.
Thank you, Mr. Kalin. The next speaker on my list is Mr. Vatslashvili. Mr. Vatslashvili, you have the floor.
Thank you very much, Mr. Chair. I thank the delegation for the information provided in the first round. In order to save time, let me move to the next round of questions, and these are issues under 17, 18, 19, and 26. Well, generally, there is no doubt that any responsible government is under the obligation to provide security to its population. And security challenges faced by the State of Israel should be acknowledged. Any responsible and democratic government is at the same time faced with a challenge to maintain a balanced approach while choosing the means in response to the existing security threats. It has been noted on a number of occasions that Israeli society is characterized by the openness with which it engages in a discussion over the quite sensitive issues. Members of academia, human rights organizations, and judiciary engaged in a critical analysis of the problems and shortcomings faced resulted from the current or past practices. And it is not surprising that some of the questions, my questions, are inspired by those debates within the society in Israel. It was former Chief Justice of the Supreme Court, Mr. Aaron Barak, who once wrote that terrorism creates much tension between the essential components of democracy. On one hand, he wrote, people may encourage steps effective to ensure security, but other pillar of democracy, human rights, may encourage protecting these rights. Protecting the rights of every individual, and at the cost of, even at the cost of undermining the fight against terrorism. I'm sorry. The true democratic accountability cannot be satisfied by the judgment of the people alone. The legislator must also justify its decision to judges who are responsible for the protection of the principles of democracy. While noting the position of Israel regarding the application of Article 9 of the covenant to the territories, and there have been a number of comments and questions from my colleagues on the issue of general application of the covenant. Let me put the question in a very simple way, and the question is really quite straightforward. Are the laws and regulations currently in place in line with the principles the judges can protect, and are there in order to protect? Recent example of Palestinian detainee, Mr. Khader Adnan, who was released as a result of the prolonged hunger strike, just before the High Court of Justice was to hear his petition, again triggered the debate in the society on the practices of administrative detention. It has been also argued that the lack of safeguards in relation to the individuals detained on the security ground immensely increases the risk of a mistake, even and assuming that the government act in a good faith when carrying out such detentions. We have heard that judicial review is provided in order to assess the grounds for the security detention. However, as neither detainee nor the lawyer are allowed to study the file and not really know what are the grounds for the detention, there is very little they can do in order to protect or defend themselves. As you may remember from the previous concluded observations of this committee, the committee recommended to grant administrative detainees prompt access to counsel of their own choosing, and bring them promptly before a judge and try them in their own or their counsel's presence. Some changes have been introduced, and these are obviously welcome. The improvements are obviously welcome. But in order to have a counsel, the counsel has to be able to actually provide protection or to provide assistance to. In General Comment 29, the committee also reiterates that measures derogating from the provisions of the covenant must be of an exceptional and temporary nature and be limited to the extent strictly required. Some NGOs reported that in 2014, the number of Palestinians in administrative detention was rising. And I would very much appreciate now the statistical information about the numbers of those detainees now, whether it has decreased after the recent events. Let me move to the issue under the last. It's the last issue, but it's not last on my list. I just prefer to now to move to the issue related to the juvenile military courts and juvenile jurisdiction. Again, various local and international organizations estimate that about 700 children are detained annually by IDF soldiers or police. There is no doubt that, in principle, juveniles may commit serious offenses which need to be responded and investigated. However, there is also no doubt that the response of authorities to juvenile offenders should be carefully balanced. When juveniles are detained, all necessary safeguards should be in place and be readily available for them. Apart from establishing the juvenile military court, in the last couple of years there have been some improvements in legal framework regulating the detention of juveniles, and this is to be welcomed and acknowledged. The improvements were made partly in response to the recommendations of the international bodies, including this committee, but also as a result of the internal debates. It is very important to realize that there were such debates, as this should give us a hope that the future improvements will be introduced without delay. According to the report, new procedures have been established and disseminated among IDF and police of the use of hand ties to prevent pain and injury. However, there have been numerous reports that these regulations are poorly applied in practice. There have been testimonies of thousands of children indicating to lack of respect to this regulation. It will be interesting to learn if there have been any response to the allegations or any improvements based on the assessment of those allegations. We have both also heard from the representative from the members of the delegation about another positive example, and that is a positive development that the age of majority in the military courts has been raised to 18 years. However, it is again, as it has been reported by a number of NGOs, these amendments do not apply to the sentencing provisions. Children aged 16 and 17 are still sentenced based on the provisions applicable for adults. Requirement of the for the police to notify parents about the arrest of children has also been introduced, and we have heard that detentions at night hours have decreased, and that regulations now require to inform children that they have the right to consult a lawyer. However, it is not entirely clear from what moment of the detention the consultations with the lawyer may occur and will be guaranteed. And it is not clear if the same requirements would apply during the detention of a minor by the IDF, by the military. Attorney General of Israel, Mr. Yehuda Weinstein, who recently stated that military court judges should be allowed to request psychological evaluations of arrested Palestinian minors. He said every minor is ward unto himself, and a minor is a minor no matter where he lives. And I believe that all of us would agree with this, on this point with him. It was also reported that military court judges favor in actually amending the law that would allow them to request such evaluation, which is routinely done by the judges in Israel. Practical difficulties and security concerns have been cited by those who oppose this change. However, let me again quote Attorney General, who stated in the same article in the newspaper, which I had a chance to read recently, that there is a need to strike a balance between the danger to the public welfare and the presumption of innocence and the possibility of rehabilitating the minor. End of the quote. Following this statement, should we expect any further amendments in the laws and in legal framework regulating the detention of the minors? Apart from that, the juvenile military courts or jurisdiction are believed to have following shortcomings, and let me briefly just list some of them. It has been reported that although it is true that minors are to be heard before a military juvenile court, remand hearings, bail applications, or extension on detention are specifically exempt from this requirement. Could you please comment on that, whether it is correct? And military juvenile judges are selected from the ranks of military court judges and are given proper, appropriate training. However, various NGOs indicate that in practice there is a noticeable distinction between the ordinary court proceedings and the proceedings at the juvenile courts. Now I'll jump back to the issue 18.
Apologies for the interruption. Could the interpreters ask Mr. Vadslashvili to speak closer to the microphone, please? Thank you.
Property, violence by the settlers, illegal takeover. I'm sorry, thank you. of the land and trespassing have been reported to be filed by Palestinians. It has also been reported that in about 2/3 of cases, the investigation has been closed, either due to the failure of the police to identify suspects or due to the failure of the investigators to collect and consolidate sufficient evidence in order to prosecute suspects who were identified. The NGOs and independent observers believe that the main conclusion from analyzing the investigation files is that the police or the military who reacted to the complaints were not able to carry out all necessary steps in the right time, in the right moment, in the right place. The State Comptroller, similarly to the NGOs, reported in 2013 that defects in the performance of the duties by IDF forces authorized to arrive at the scene of crime and detain those involved actually contributed to these unfavorable statistics. One of the NGOs also quoted the report of the State Comptroller saying that at times, IDF forces fail to fulfill the provisions set forth about the required behavior of IDF forces arriving at the scene, and the reason for that is the lack of a training provided to the relevant personnel. Well, based on this information, again, I would very much appreciate the comments from the delegation, if there have been any measures taken or planned to be taken to respond to this. And very briefly, just to finalize my intervention, there have been also, the information was provided by the report that the state is planning to adopt the law, and this bill is currently in the Knesset regarding the fight terrorism bill. There have been a number of concerns with regard to this piece of, this bill, that it contains provisions which are not clear, actually are vague, although as state reports, the whole idea about implementing the positive side of in case if it is implemented and adopted, is that it will provide a clear definition and clear criteria of what terrorism is and who might be who may face charges in case of on the basis of this law. But very little information was provided with regard to the bill, with regard to the content and the particular definition. So any additional information and comments on this regard will be also very much appreciated. Thank you very much, Mr. Chair, and I thank the delegation beforehand for the information.
And thank you, Mr. Vatslashvili. The next speaker on my list is Mr. Flinterman. Mr. Flinterman, you have the floor, sir.
Thank you, Mr. Chairman. And I would like to thank first the delegation for the replies to my questions this morning. I have two short follow-up points. First of all, I regret that the position of the delegation on the extraterritorial applicability of the covenant is unchanged, referring to somewhat disputed legal and factual grounds. And it's a small comfort, as the English say, I think, a Dutch comfort, to be informed that the matter is still being discussed. And I do hope that the arguments put forward on this particular issue during the debate today and earlier in the exchange between the committee and the delegation in 2010 and earlier years will play an important role. And of course, the Human Rights Committee will continue to hold Israel as a state party responsible and accountable for its respect for human rights in all situations where it exercises state and governmental powers and is exercising effective control. I also regretted the reply to the question on the principle of equality. Yes, indeed, I've read the reports and I've noted the great significance that has been attached to that particular principle by the judiciary in Israel, especially the Supreme Court. The Supreme Court considering the principle of equality as implicit, inherent in the concept of human dignity. Yes, indeed it is. But what? And that was the question raised by my colleague at the time, Mr. Telin, in 2010. What political considerations stand in the way of making the implicit character, the implicit notion of the principle of equality explicit in the basic laws? What political considerations stand in the way? What obstacles are there? And my question to the delegation would be to inform the delegation somewhat more about the discussions on that particular issue. And that brings me to the questions in my questions in the second round, the questions relating to raised in issues number 20 and 21 on the freedom of movement and 25 on the protection of the family. The issues raised by the committee and the questions raised in issue 20 and 21 have been answered in a very short manner by the State Party by referring to the answer to issue number 4, that is the issue on the extraterritorial application of the covenant. But in light of the openness and the willingness this morning exhibited by the delegation, I would like to repeat some of the questions that are on the list of issues, in particular the question of whether the State Party envisages reviewing military order number 1649 and 1650 to ensure that any person subject to a deportation order is heard and may appeal the order to an independent and judicial authority. And the second question, whether the State Party has taken any steps to allow and facilitate the displaced persons of the population of the occupied Syrian Golan to return to their homes and to recover their property. And moreover, I would like to submit a few issues that have been brought to the attention of the committee relating to the issues raised in question 20. First of all, the implications of the blockade of Gaza as part of a wider separation policy, in which travel from the Gaza Strip to Israel and the West Bank is prohibited, and which often had such a dramatic impact during the recent hostilities in the summer of 2014. And secondly, whether the delegation could inform us about the impact of the barrier and the continued construction thereof, despite the advisory opinion of the International Court of Justice in 2004. The implications that have been brought to our attention are that there is only a very limited allocation of permits and a restricted number and opening times of the barrier gates. And in particular, it has been brought to our attention the difficulties for Palestinians living in the seam zone to access essential services. And my concrete questions are, why are so many applicants for permits rejected? There seems to be a 50% approval rate. Secondly, why are not all gates open on a daily basis? We have been informed that only 9 out of the 81 gates are opened. And third, what measures is Israel envisaging to comply with the International Court of Justice advisory opinion of 2004 in order to ensure that Palestinians have access to their lands and livelihoods? And four, are any measures envisaged to review thoroughly the status of all long-term residents in the West Bank and to ensure that they are issued with a valid permit and registered in the population registers? And I also would like to share concern about information on the policies of Israel relating to Palestinians living in occupied East Jerusalem, which has as one of its implications that most people living in the occupied Palestinian territory are deprived of their freedom to choose residence in their own country including East Jerusalem, and which seems to treat Palestinians in East Jerusalem as foreigners or immigrants in their own country. And that brings me to issue number 1. And again, as I said, there is no answer, but I would like to invite the delegation in the framework of our dialogue to respond to my queries. First of all, issue number 21 deals with the question of the Israeli settlements in the occupied Palestinian territory, including East Jerusalem and in the occupied Syrian Golan Heights. And of course, it's not within our remit to assess and express ourselves on the political implications of the settlement policies and the underlying of the settlement policies, including the recent announcement of further expansion of the settlements. Our task is to assess those settlements and their underlying policies from the perspective of Israel's obligations under the covenant. And it was from that perspective that in the concluding observations of 2010, the committee called on Israel to cease all construction of settlements in the occupied Palestinian territory, including East Jerusalem and in the occupied Golan Heights. But now we have information before us from which it appears that the construction of settlements has more than doubled over the past years, and that further expansion plans have been announced. We have information before us about the resumption of the practice of claiming lands as state land by the so-called Blue Line Task Force. We have information before us about the practice of retroactively legalization of outposts as new settlements. And further, we have information on the expansion of settlements through informal methods, such as the creation of agricultural and archaeological projects. And all this is done, I think, at the expense and detriment of Palestinians living in the occupied Palestinian territory, including East Jerusalem and the Syrian Golan Heights. They are violated in their basic rights to liberty and security of persons, to be free from inhuman, degrading, or humiliating treatment, and the right to access to legal remedies and freedom of movement. And it seems that the settlement policy is undermining the right to self-determination. And I would very much appreciate the dedication to address these concerns that I have put forward. And then finally, on the issue of the protection of the family, issue number 25, relating to the protection of the family, Article 23. I have a few questions on, in relation to that particular concern raised in the list of issues. Well, first of all, it is the question of whether the state party would be able to provide data and information on the impact and effects of the citizenship and entry into Israel law, in particular data concerning the impact of that law on women and children. The state report informs us that the state party, that the High Court in Israel has upheld the constitutionality of the citizenship and entry into Israel law, and that the court has ruled that even if the law harmed the rights of Israeli citizens, the infringement was proportional and did not violate basic laws. In practice, however, the law has had the effect of preventing almost all family reunification for Palestinian citizens of Israel and Palestinian residents of East Jerusalem with non-resident spouses and children, on the grounds that they are an automatic security risk and that the security benefits of the law outweigh the negative impact of the restrictions that is placed on family unification. And my question to the delegation would be whether it would be willing to explain how prevention of family reunification on the grounds of an automatic security risk is proportional, and whether that is in compliance with the state party's obligations under Article 23. And then the state party report submits that in order to maintain contact with their families, security prisoners are entitled to send and receive letters. They are entitled to receive family visits, unless there is a specific security prohibition on such visitations. Would it be possible for the delegation to provide statistics of the number of visits prohibited for such reasons? More in general, what measures does the state party envisage with a view to facilitating family reunifications? And then finally, in the state report, the state party submits that it has reinstated the family visit program supported by the International Committee for the Red Cross. In light of the most recent developments in Gaza, can the delegation give us an update on the status of that family visit program? And that, Mr. Chair, are my questions in the second round. And thank you very much.
Thank you very much, Mr. Flinterman. The next speaker on my list is Ms. Vattenfall. Ms. Vattenfall, you have the floor.
Thank you, Mr. Chair. I thank the delegation for the answers they have provided so far. I am responsible for issues number 22, 23, and 24. On 22 is the freedom of religion. We are pleased with the measures taken by the state party to protect the rights of religious minority and to ensure equal and non-discriminatory access to places of worship for Christians and Muslims. But there are some concerns. From the information in front of us, we know that there is restricted access to religious sites and places, and there is an age restriction on Palestinians who wish to enter the Al-Aqsa Mosque. Men who are over the age of 50 and women who are over 45 are allowed into the mosque with no restrictions. Those that do not fall into the required age group are denied access. In February 2012, Israeli settlers broke into the Al-Aqsa Mosque under the protection of the Israeli police, and this resulted in verbal and physical assaults. We would like you to elaborate more on this and comment on this. That was on issue number 22. On the issue on 23 is on the conscientious objectors. I need some clarification when I read through your reply. In paragraph 419 and 420, you describe two procedures for an application to be reviewed in order to be exempted from military service or not. One procedure is to determine whether the applicant could be referred to a committee. The second procedure is to establish if the applicant is eligible for exemption. This second committee recommends to the authority to decide if the applicant is eligible for exemption. And this authority is the chairperson of the committee. And in this regard, I have some questions. Is there a hearing for the applicant in both procedures? What are the criteria used in both proceedings? And do applicants know the criteria used? How many persons have applied for the exemption in, let's say, last year, 2013? How many were denied exemption? How many accepted? And how many of these applicants were denied or accepted in appeal, because they can appeal the decision if denied? In paragraph 418 and 419, you mention for reasons of conscience. And then you also said in in paragraph 420, for reasons of conscience due to a pacifistic point of view. Can you give us the difference between those two reasons of conscience, and the one is due to a specific point of view? In paragraph 426, the committee are of a different view, because people refusing military service have been imprisoned repeatedly. And in the committee's view, is this a violation? This is a violation of the principle of nabis in idem. Maybe you can elaborate more on this issue. With regard to issue 24, that's the freedom of association of human rights defenders and freedom of opinion and expression. With reference to paragraph 431 of the replies, we would like you to explain the court's judgment in the High Court of Justice 73/453, where you have the limitation on the freedom of opinion and expression. And I quote, with several exceptions, freedom of expression may be restricted by official action only if, in the specific circumstances of the case, the speech in question gives rise at least to, and unquote, near certainty, unquote, that the public peace, broadly construed, will be endangered, and only if other means to lessen the severity or the likelihood of such a violation of public peace are of no avail. My question in this regard, can you give us some examples of the several exceptions? And also, what is meant by near certainty? Yeah, near certainty. And also, yes, the examples of several exemptions to justify the restriction on freedom of expression. We also like to hear more about the boycott law and why there is so much objection against this law. There is also objection on the limitation on freedom of association. Can you elaborate more on these limitations, which people find unjustifiable? With regard to the obligatory disclosure of receiving support by a foreign political entity, there is concern as new restrictions on NGO are undermining the human rights. That's what we have in front of us. And that's the concern. And there's also concern that this law could have a major impact on human rights organizations and humanitarian organizations, subjecting them to rigorous reporting requirements, forcing them to declare foreign financial support in all public communications, and threatening heavy sanction for non-compliance. We would like you to comment on this. And I have also one question in this regard. Does this law apply to all foreign funding organizations? And I thank the delegation in advance for their replies, and I thank you, Mr. Chair. Thank you.
Thank you, Ms. Vattenfall. The next speaker on my list is Mrs. Zlatescu. Mrs. Zlatescu, you have the floor.
Thank you very much, Mr. Chairman. I will speak on the water issue in Gaza. Certainly, human rights violations against Palestinians are totally contrary to Israeli laws and Israeli policy. Yet the water crisis in Gaza is different from the other infrastructure crises. Unlike its provision of electricity, Israel currently provides only limited quantities of water to Gaza. The 1993 Oslo agreements made the Palestinian Authority responsible for water management in Gaza, and in 1995 the PA established the Palestinian Water Authority, PWA. In other words, from that point on, all matters involving water care, at least until recently, were exclusively in Palestinian hands. Thus, I assume that Gaza's water crisis was generated by poor management on the behalf of Hamas and the Palestinian Authority, and was not caused by any Israeli action or misstep, with the exception maybe of inadvertent distractions during conflict incidents. Still, Israel is the only actor capable of extricating Gaza from the crisis, meaning that it has a lever to help achieve strategic objectives. In 1995, the United States Agency for International Development, USAID, and other international organizations prepared a comprehensive plan for solving Gaza's drinking water problem by 2000. That was the initial plan. The plan including repairing the pipelines, reducing the use of well water, treating sewage, creating infrastructures for the desalination of seawater, and importing drinking water from Israel. However, in 2000, the second Intifada broke out, and that brought an end to the plan. If it still had a chance, the elections that brought Hamas to power in 2006 and the resulting international boycott led USAID to close its offices in Gaza and cancel the tenders with the contractors, precisely when international measures were necessary to rescue Gaza once again from its water calamity. Where do things stand at the present? Several infrastructures for drinking water, sewage, and electricity are close to collapse, not only endangering Gazan life in the immediate context, but also posing the danger of a total lack of drinking water in the near future, which could lead to various epidemics that would affect both Israelis and Palestinians. The state of affairs conclusively rules out the opinion of building seawater desalination facilities quickly due to the large quantity of sewage that has entered the seawater, the lack of an electricity network for the desalination facilities, we have learned, and the lack of an array of pipelines that are not leaking. In any case, these matters are abstract because no action has been taken yet, and even if it is taken, it might be too late for the fast deteriorating situation. Israel's position until now has been made clear. That it is willing to help with the rehabilitation of Gaza's drinking water system, but not in a humanitarian framework. Instead, this must be done in the context of a binding political agreement entailing the rehabilitation of the civilian infrastructure in return for the destruction of the terror infrastructure. This is what we hear from Israel. However, the only thing that can save Gaza now from disaster is the plan to transfer drinking water from Israel. Does Israel have any strategy in place for what seems, yes, now to become sooner or later a major wide-ranging humanitarian emergency? Thank you very much.
Thank you very much, Mr. Zlatescu. The next speaker on my list, el próximo orador en mi lista es el señor Salvio.
Mr. Salvio, you're my next speaker on my list. Thank you very much, Mr. Chairman. Although it's a little late, with your permission, I would like to extend more welcome to the delegation of Israel, given it's the first time I take the floor. Such a sizable and competent delegation we have before us. I'm aware of the fact that we have little time available. I'll just take 2 minutes, sir, to help you, Mr. Chairman, and to say the following. A comment first and a question. The comment has to do with the way in which the state is interpreting the implementation of the covenant. I share what was said by my colleagues previously. Reference has been made to the Vienna Convention on the right to the treaty law, the VCLT, but nothing in the VCLT makes it possible to interpret the covenant not territorial on a territorial basis. On the contrary, Article 31 of the VCLT obliges us to interpret covenants in accordance with the objects and purpose thereof, and a human rights treaty has the purpose to implement to make these rights applicable to all persons under the jurisdiction of the state. And under jurisdiction in terms of human rights, that means much broader than under the general jurisdiction of international law. For example, under the current interpretation given by the State of Israel, to the situation. The Israeli citizens who are in the occupied territories do not benefit from the protection of their rights under the covenant by the State of Israel. And I'm convinced that the state won't want to generate a discrimination between its citizens when it comes to guaranteeing human rights. That's the first comment I wanted to make. I hope that in the next meeting we have with the State of Israel, I was in the debate 4 years ago, that in our next meeting you will have thought about these matters and that you'll bring your position in line with the position held by the international community in terms of jurisprudence and how we understand the implementation of the ICCPR. My question, that was my comment, my question is the following. I'd like to refer concretely to an answer we heard from you to the question put by Ms. Vataval in terms of equality of rights when it comes to divorce. From what you said, I understand that you need the consent of both spouses for divorce to be pronounced. But when the woman asks, so is it the case when the first request is made by the woman or by the man, or when it's only the woman asking? Because if it's only when the woman making the first request, then undoubtedly it's difficult to make this principle compatible with the principle of non-discrimination enshrined in our covenant. So that was my comment and my thought and my question. Thank you very much, Mr. Chairman.
Thank you very much, Mr. Salvioli. And before I suspend the meeting, I'd like to ask one follow-up question myself. Well, I didn't. I'll continue with my question and then give the floor to Mr. Fatala. The question I have is a follow-up question in relation to optional protocol 2, the death penalty one. Israel has a lot to pat itself on the back in respect of the death penalty, and I didn't quite understand what it is in the legislation that prevents ratification of the protocol. The protocol requires that no one be executed. The protocol does require that measures be taken to move towards abolition, but it also permits reservations in respect of death penalty in time of war, pursuant to a conviction for a most serious crime of a military nature committed during wartime. If a reservation is made to that effect, then such a reservation is admissible under the protocol. Could we know what it is in Israel's legislation that genuinely prevents ratification of that protocol, which would, of course, be a much-needed feather in the cap of Israel during our next session? Mr. Fatala, you have the floor.
Thank you, Mr. Chairman. It's a follow-up to the question I raised this morning concerning the annexation of Palestinian land and depriving the Palestinians from their natural resources. I got a very general reply to this issue. I gave this morning a very concrete example combining these two issues, and what I need really it's to give a clarification about this clear example I gave this morning and what is happening concerning this annexation of almost 1,000 acres and the restriction for the Palestinians to get access to their natural resources and, in the villages near Beit Lahm. Thank you, Mr. Chair.
Thank you, Mr. Fatala. And with that, I'm going to suspend the meeting to give the delegation time to concert its responses. The meeting reconvenes at 4:30. The meeting suspended.